It's Nolan. I heard them saying that we lost diversity in rap. How the fuck is that when y'all just been supporting trap? I'm charged up like jumper cables, dropping with no label, breaded up like bagels, finna wipe these niggas off the map. I got some shit in the tuck you ain't heard of, sipping Bloody Mary, my lyrics on bloody murder. Your name in my journal circled, I'm riding with your bitch, yeah, we out in murder. The second coming to greatness, I feel like color purple. I'm on the level y'all ain't ready for. Shout it, want the wood, I'm a cutting boy. Been a legend in Atlanta, bitch, I'm Pastor Troy. Pretty boy, but that money finna pull a Floyd. The jewels sparkle in that water, pass me a LaCroix. River Daily, you never needed the alias. Independently checking my Nikes, came from them avias. I've been on my hustle, car shuffle, niggas hearts muffled. If you want trouble, got muscle like WrestleMania. Boy, stop. We looking at Porsche drives, been rapping 20 years. I'm insuring my voice box. They call me unorthodox. I'm orthodontic when it come to profit. Safety first, but let me switch the topic. Y'all rappers all in my DMs to promote your tracks. Every morning logging in, I report the trash. You gotta take it on the chin if you want it bad. I'm used to it, I've been through it. I'm using my point of view as an influence. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everyone is doing well today. Now, the first video we're going to be doing is getting into the update in Cardi B and Tasha K's ongoing saga. Of course, we know that Cardi B filed a defamation suit against Tasha. She won. But now the battle that they're currently going through is about her receiving her actual money. I believe that she's owed $500,000, which was very lenient, to be honest, because she could have pressed to receive more. But I think they settled for $500,000. And Cardi B is saying, hey, she's not paying me my money. And I have reason to believe that she has income coming in that's not being properly reported. She's filed bankruptcy and she is fudging the numbers. She's fudging her income and she's putting her assets and her income in businesses owned by her husband rather than herself. Okay? Those are the primary allegations. Now, there is a very long filing. I have the filing. We'll go through the filing. But you got to understand this thing is like 50 something pages. It's going to take all day damn near to read through this thing. Now, because I know y'all have grown accustomed to me going through these things, I am going to go through it. But again, as I stated, if we get to a certain point where it's just repetitive talk, we'll skip through it and just kind of get to the main points of argument coming from Cardi B and her attorneys as it pertains to Tasha K. Now, y'all know I've been covering the Megan Thee Stallion Milagro Grams situation as well. Some people are, comparing the two. And of course, it does kind of deserve a bit of comparison because we're talking about big stars in female rap that are basically coming after what people would determine as bloggers or people with a platform, kind of gossip or, just independent media of some sort, right? And they come out and they spew negativity, spew inaccurate information, make certain allegations about these people. And, it's becoming more commonplace based on the precedent set by Cardi B that people are going to start receiving these lawsuits for defamation, malicious intent, all those things. So let's go ahead and pull up what Cardi B and her team are talking about. All right. So here is the filing. Let's go through it. Okay. Now, this is filed via United States Bankruptcy Court. Again, Tasha K filed for bankruptcy and she was trying to, I believe, file bankruptcy, hoping that she wouldn't have to pay her debts. And Cardi B ain't playing that shit. Okay. So we've got here Belcalis, Marlenis Almanzar, that's Cardi B. in her motion to dismiss Chapter 11 bankruptcy case, or in the alternative, convert the case to a case under Chapter 7 of the Bankruptcy Code. Now, give me a second here. I want to go ahead and look up the difference between Chapter 11 and Chapter 7 bankruptcy, just for clarification purposes. So in quick summary, before we get into all this, Chapter 11 bankruptcy, according to the United States courts, individuals and business entities can enter into Chapter 11. Typically, this type of bankruptcy is a reorganization of a business. Through the bankruptcy, the debtor restructures and then creates and implements a plan to pay back their creditors. The plan must be approved by a trustee appointed by the court. The trustee is typically in charge of implementing and overseeing the plan, ensuring that the business has the income and resources to follow through with it. Once the plan is completed and confirmed, any remaining debts under the bankruptcy are discharged. Okay? As it pertains to Chapter 7, they say the main difference when it comes to Chapter 7 versus Chapter 11 bankruptcy is that Chapter 7 is a liquidation plan. That means there's no repayment plan associated with a Chapter 7 bankruptcy, which is what Cardi is trying to either dismiss Tasha's Chapter 11 in totality, or get it converted to Chapter 7. Okay? Now, when you file Chapter 7, you typically agree to liquidate your assets to pay off as much of your debt as you can. The remaining debts that are part of your bankruptcy are dismissed. Okay? So that would mean that Tasha K is forced to sell her assets off so that she can pay off as much as possible toward the debt. I think that's the simple way to describe it as it stands in front of me. They say if your income is above the state minimum, you must pass a means test. A bankruptcy attorney can quickly apply these tests to help you understand. You don't have to give up everything you own in a Chapter 7. You may be able to keep exempt assets, which can include personal belongings. You may also be able to keep your home, a car, and other items even if you owe money on them, if you could continue to make timely payments on those debts, which Cardi B says they haven't been making attempts to do. All right, that's the simple description. Now, let's get back to the filing. And let me see if I can make this a little bit bigger for y'all. Okay. So, Belcalis Marlenis Almanzar, buying through undersigned counsel, moves this court pursuant to 11 USC 105A and 1112B of Title 11 of the United States Code, blase blah bankruptcy code, for an order dismissing the Chapter 11 bankruptcy case of Latasha Transira Kibi with prejudice to the filing of a petition under any chapter of the bankruptcy code for a period of 2 years from the date of the order of dismissal, or in the alternative, converting the case to a case under Chapter 7 of the bankruptcy code. In support hereof, Ms. Almanzar states, the bankruptcy code is designed to provide relief to the honest but unfortunate debtor. However, the debtor in this case is neither honest nor simply unfortunate. So they coming in slanging heavy mud, right? Because, hey, that's what Tasha did in order to get herself in this situation. Why not? Her actions both before and during the bankruptcy case exemplify fraudulent intent, bad faith, and abuse of the bankruptcy process. As detailed below, following her loss in the defamation action and in the direct defiance of the Federal District Georgia Court's explicit admonition not to transfer assets or otherwise impede the collectability of the amended defamation judgment, debtor and her husband, Mr. Kibi, I'll just say, orchestrated a months-long scheme to hinder, delay, and defraud Ms. Almanzar's collection efforts. Specifically, debtor and her husband engaged in the following conduct. So here is where Cardi begins to outline how they've been trying to avoid proper payment. A, fraudulent personal asset and income transfers. Debtor transferred certain assets and income streams to her husband and or his business, Yellen Entertainment, LLC, to hinder, delay, and defraud Ms. Almanzar's collection efforts on the amended defamation judgment. B, fraudulent business asset and income transfers. Kibi Studios, LLC, which is a business jointly owned by debtor Tasha and her husband at the time of the defamation action, transferred its assets and income streams to Yellen. So they're saying that Tasha's Kibi Studios, which she owns with her husband, have transferred their income streams to Yellen LLC, which is a company solely owned by her husband, which operates as a mere continuation of Kibi Studios without any ownership interest held by the debtor. These transfers were executed with the express intent to hinder, delay, and defraud Ms. Almanzar's efforts to collect on the amended defamation judgment. This scheme was specifically designed to shield debtors' income and assets derived from Kibi Studios and to circumvent the $500,000 judgment against Kibi Studios outlined in the amended defamation judgment. Okay, now part C. Untruthful and misleading bankruptcy filings. Debtor filed bankruptcy schedules under penalty of perjury that omitted and or misrepresented certain of her assets and overall financial condition. Okay? Pursuant to 18 U.S. Code 152, knowingly and fraudulently concealing assets, making false statements under penalty of perjury, or withholding recorded information related to the property or financial affairs of a debtor is a federal crime, subject to fine, imprisonment up to 5 years, or both. So they saying you either gonna pay up or your ass finna go to jail if the judge says it's just. Here, debtor and her husband, I don't want to, provided knowingly false statements under oath regarding the reasons for transferring certain assets to her husband. For example, they get into a residential home that she owns that she transferred over to her husband. I don't want to get into no address names. Okay. They also provided knowingly false testimony regarding the existence, ownership, and control of undisclosed partnerships in onshore, offshore trusts, and misrepresented the business and financial relationships by and among debtor, her husband, Kibi Studios, and Yellen. For example, Mr. Kibi, which is her husband, testified untruthfully that Yellen is owned 50-50 between him and his brother, Lasana Kibi, who resides in Mali, Africa. Mr. Kibi further testified neither he nor his brother have ever taken a distribution from Yellen. Okay? So basically they're stating that Tasha's husband and his brother own this business, Yellen, 50-50, or at least that's what they told the courts. And they say they've never taken a distribution from the company, meaning that they don't really pay themselves from this company. In fact, Kibi's tax returns clearly reflect Mr. Kibi owns 100% of the interest. So according to the tax returns, it's not a 50-50 business. It's only owned by Tasha's husband. And Yellen's tax returns also show that Mr. Kibi has in fact received distributions as the 100% owner. Worse, debtor's plan, debtor as in Tasha, furthers the lie that Yellen is a 50-50 owned business between Mr. Kibi and his brother. Thus, Mr. Kibi and debtor Tasha are either lying to the IRS or to the court as to the true ownership of Yellen. Crucially, it was only after the claimant, that would be Cardi, at significant expense, uncovered the concealed truths and partnerships that debtor belatedly amended her schedules and disclosed their existence in her amended plan. So they're saying we had to pay a handsome amount of money to even uncover these concealed truths or lies, as Cardi and team are alleging, right? To even understand what's been going on. Debtor's post hoc, self-serving justification for this concealment is not only implausible, but also fails to address and does not cure the fraudulent concealment of the trusts and partnerships from debtor's schedules or the repeated false testimony denying their existence. Notably, debtor spent over $25,000 to establish offshore trusts. Okay, so now she's saying that Tasha K has spent $25,000 to establish offshore trusts so that she can have some money, pent up somewhere that she can have access to if needed. Debtor's bad faith in filing for bankruptcy is further evidenced by her acknowledgement that she knew prior to filing for bankruptcy that the amended defamation judgment is non-dischargeable. It is black letter law that a judgment arising from an international tort involving willful and malicious injury, such as the amended defamation judgment, is not dischargeable, in bankruptcy, meaning you can't get rid of this just because you filed for bankruptcy. Notwithstanding this, both debtor and her husband repeatedly testified under oath that the primary purpose of the bankruptcy filing was to obstruct the claimant's collection efforts. This was one of the few points of consistent testimony between debtor Tasha and her husband. Debtor's bad faith with respect to plan negotiations. Additionally, debtor's bad faith is further demonstrated by her and her counsel's conduct during negotiations over the financial terms of the second amended plan. The court may recall the following representation made by debtor in her motion to continue the confirmation hearing filed on October 30th of this year. The debtor and her largest creditor, Cardi B, have reached an acceptable resolution of the matter. However, they continue to work on the specifics to be included in the debtor's yet to be filed amended plan of reorganization, and the parties are concerned that there will not be sufficient notice of the amended plan to all creditors prior to the scheduled confirmation hearing on November 19th of this year. Okay? It has since become evident that debtor intentionally and repeatedly misled Cardi, the subchapter V trustee, and the court at significant expense to Ms. Almanzar. Following a judicial settlement conference with Judge Hyman on June 14, 2024, and a subsequent meeting at the offices of debtor's counsel on June 24, 2024, attended by debtor, Ms. Kibi, his counsel, Ms. Almanzar's counsel. So they all had met up. Tasha, her husband, his legal counsel, Cardi's legal counsel, flying in from out of state, the undersigned and the Chapter V trustee. The parties came close to agreeing on the required plan payments though further negotiation was necessary. So they came up with some sort of plan. They almost came to something that would have been, I guess, amicable at the least. But there was still further negotiation that needed to happen. On August 22nd, debtor's counsel tentatively agreed to Ms. Almanzar's proposed monthly payment amounts contingent on debtor's approval. So Tasha's legal team spoke with Cardi and her team. They came up with a proposal for monthly payments that Tasha was going to be on the hook to provide. But Tasha needed to approve it to say, hey, I can make these payments. A counter proposal from debtor's counsel was received and accepted by Ms. Almanzar September 9th. This agreement was reflected in drafts of the Second Amendment plan circulated by debtor's counsel on and after November 19th, which included the agreed upon payment schedule. However, on the day that the Second Amendment plan was due to be filed, debtor, as in Tasha, in bad faith, unilaterally altered the agreement, agreed upon monthly payments in the second amended plan that was filed, and further cherry picked out certain critical protections for creditors that also had been previously agreed between the parties. So at the last minute, she started trying to make changes. Debtor's true intentions were revealed when debtor's counsel informed the undersigned that the planned payment terms were merely aspirational and that no formal agreement had ever been finalized. So now they're trying to play with the language, play semantics. Aspirational, as in that's what we hoped for, but it was not finalized. Debtor's position is not only demonstrably false, but also puzzling for two reasons. One, the total amount to be distributed in the planned payment schedule remains identical to the total amount set forth in the earlier drafts that incorporated the agreed upon payment schedule. So they're saying, how could this be aspirational when it's been pretty consistent in all of our negotiation? While payments to unsecured debtors are reduced in the first year, they are consistent with the agreed terms in years 2 and 3 and increase in years 4 and 5 when the projections are most speculative and unsupported by historical evidence. Given these facts, it is difficult to understand how debtor can now disavow the agreed planned payment schedule as merely aspirational. If the schedule was aspirational before, it remains so now, especially since the feasibility of the plan still hinges on several speculative factors, including the Yellen contribution, totaling roughly 3/4 of the funds available for planned payments. So they're saying 3/4 of the money available for Tasha to even pay is going to her husband's business, which she has no association to as far as paperwork is concerned. Assumptions that debtor will be able to increase her ticket prices over time. So that's the money from Tasha K's comedy shows and touring and stuff that she's been doing, because she has been doing shows. So they're saying that hopefully she'll be able to increase her ticket prices over time as she continues to grow her brand as a performer. She'll be able to make more money. Therefore, it would increase her ability to make payments. Of course, they're saying if it was aspirational then all of these factors today are also aspirational, which actually seem questionable, right? The production of additional content by debtor, that's Tasha, right? We know she's got a very prominent YouTube page. We'll say that, so they're basically saying if she can ramp up additional content on her channels and her website, then she'll be able to make more money, which then would create more faith in her making payments, right? Ms. Almanzar was prepared to accept the risk of debtor defaulting under the agreed upon planned payment schedule only on the condition that the safeguards or guardrails she proposed were fully incorporated into the plan. Ms. Almanzar reasonably believed this was the case as the guardrail provisions appeared in successive drafts of the second amended plan, right? So there were certain things that were going to be like making sure that these things happen, right? At the risk of defaulting, basically saying, we'll set down this agreement. It's possible you could fuck me, right? In non-legal terms. But since we have these safeguards or guardrails incorporated into the plan, which could possibly be additional penalties if she doesn't make the payments at a required time, right? You got to have something to keep you in check, right? So she says, if we put these in there, then I'm willing to work with you, right? But then all of a sudden, they start getting different tunes from Tasha and her legal team. However, the filed version of the second amended plan reveals that many of these critical protections were selectively removed without the knowledge, consent, or agreement of Cardi. This demonstrates that debtor had been engaging in bad faith negotiations, leading Cardi throughout the process at tremendous temporal and financial expense. Okay? Which makes sense because you're paying your legal counsel for their time for these negotiations to outline these things in paper, only for your debtor to come back and make substantial changes without consulting with you first, which means we wasted our time creating this draft. I'm paying them to create the draft. And now I got to pay them additional time to fix this, to chase you down. And I'm having to pay money to dig into your financial records to see where your money is going and that you're not properly reporting this stuff to the courts or possibly the IRS, whichever you want to say. You're lying. Right? Finally, as will be detailed in a separate objection, in addition to debtor being unable to meet her burden to satisfy the good faith requirement of 11 U.S. Code 1129A for plan confirmation, the second amended plan is facially unconfirmable. It is highly speculative, misrepresents debtors' income and expenses, and perpetuates the long-running fraudulent scheme to shield debtors' assets and income from creditors, particularly Cardi. In light of the totality of circumstances, Cardi respectfully requests that the court find debtor's petition was filed in bad faith and enter an order dismissing the bankruptcy case with prejudice, imposing a 2-year ban on refiling under any section of the bankruptcy code. So they want to throw her petition for bankruptcy out, and they want to say you can't file again for another 2 years Now figure out how you finna pay this woman. Okay? Factual background, defamation action, and judgment for claimants. So this is going to take you back into time with how we even got here in the first place, right? As a result of debtor's malicious and intentional campaign to damage and destroy Ms. Almanzar's reputation among her fans and consuming public, not to mention debtor's efforts to monetize the defamation for greed and spite, on March 21st, 2019, Cardi commenced an action in the district court for the Northern District of Georgia against Tasha and her studio, Kibi Studios, among others, in the case styled Belcalis Almanzar versus Latasha Kibi. On January 10, 2022, Georgia District Court commenced a jury trial lasting multiple weeks in which the jury ultimately found debtor and co-defendant Kibi Studios liable to Ms. Almanzar for defamation, invasion of privacy, false light, and intentional infliction of emotional distress, and further found debtor to be jointly and severally liable for the damages with co-defendant Kibi Studios, right? So there was a jury trial and they said, guilty, you need to pay. As a result of the jury verdict on February 17, 2022, the Georgia District Court entered its judgment, the original defamation judgment, in favor of Cardi and against debtor and Kibi Studios. July 19, 2022, the District Court for the Northern District of Georgia entered the amended defamation judgment, pursuant to which the District Court awarded $1 million for pain and suffering and or reputational injury and for medical expenses against defendant and Kibi Studios jointly and severally. $1 million in punitive damages against defendant and $500,000 against Kibi Studios and $1.3 million for litigation expenses. Gee, damn. Hold on. So this was $1 million for pain and suffering, $1 million for punitive damages. That's already over 2. You put the $500,000, that's 2.5. And then they come with another 1.3. That 3.8, that's down there $4 million. Down there $4 million. And Cardi B reduced it to $500,000. Being lenient and you still don't want to pay up. On March 22nd, 2022, Ms. Almanzar initiated garnishment proceedings in Gwinnett County. March 21st, 2023, the 11th Circuit Court of Appeals affirmed the Georgia District Court's amended defamation judgment. April 4th, 2023, $9,300 was garnished from Google. So this was directly taken from Tasha K's YouTube income. An additional $1,000 was garnished from Chase Bank. However, the garnished income was not distributed to Ms. Almanzar, and remains in the trust account of Ms. Almanzar's state court counsel, Daniel Silos. So they took a little over $10,000 from Tasha on April 4th of last year. Okay. But that additional $1,000 is still sitting in the trust account of her state counsel. May 25th, 2023, in furtherance of her efforts to hinder, delay, and defraud Ms. Almanzar's collection efforts, debtor filed the above captioned bankruptcy case. So right after she made her first payment, she had $9,000 come in from a Google payment. So they took her entire Google check from YouTube. She said, hold on, y'all ain't finna keep. I made damn near $10,000 this month off this shit. I'm out here producing content. Y'all not finna take my whole paycheck. I feel you. But this ain't, hey, man. You got yourself here. So the very next month, in furtherance of her efforts to hinder, delay, and defraud Ms. Almanzar's collection efforts, debtor filed the above captioned bankruptcy case, even though she knew at the time that the amended defamation judgment was non-dischargeable. Worse, debtor continues to live her life in luxury. All right, so she's saying, hey, we got one little payment off you. You tried to file bankruptcy knowing that we were still going to be on your ass. But now, keeping up with your expenses and the life that you live, you're not as unfortunate as you claim. For example, in the post-petition period, the debtor and her husband moved into a more expensive apartment compared to their pre-petition residence, which I guess would be previous residence. I don't know. With a monthly rent approximately $7,000. So y'all paying $7,000 in rent. Additionally, the debtor's social media account showcased her wearing what appears to be high-end clothing. Oh, damn. You got a $7,000 a month apartment. You out here wearing nice clothes, handbags, and jewelry. Plainly stated, the debtor continues to evade accountability for her willful and malicious actions against Cardi, maintaining a luxurious lifestyle without making any payments toward the amended defamation judgment. In contrast, Cardi has been compelled to incur substantial expenses to enforce the judgment. Again, she's been paying money to her legal team. She's been paying for financial audits to see where the records are being filed and how they're being filed. So she's saying, I'm taking financial losses, right? To uncover the debtor and her husband's concealed assets and false testimony given under oath. And again, that's under the penalty of perjury. Debtor and her husband hindered, delay, and defraud claimants' collection efforts. Okay? So they really swinging for the fences here. Because Cardi tired. She basically said, I got one payment from your ass. We got about $10,000. And we still got $490. Plus, if they start putting interest on this, plus additional attorney's fees, she might be paying even more. Damn near $1 million all over again. Now, what is this here? On January 25th, 2022, after reading the jury verdict of the conclusion of the Georgia defamation action, the federal district court admonished debtor and her husband not to transfer their assets. So they told her not to start fudging with assets, not try to, dodge accountability. The court says, I want to say this to the defendants. You have, this is a very substantial verdict that has been rendered against you, and your ability to satisfy it is independent of the fact that it exists. So they're saying whether or not you can pay it is your fault, right? I would just caution you, not knowing what may have been transcribed, what may have been dischargeable. Debtor has diverted assets and income to her husband and his companies, ensuring minimal distribution to creditors over the life of the plan. These transfers are clearly fraudulent, as they are admittedly designed to hinder and delay Ms. Almanzar's collection efforts by the amended defamation judgment. By simply refiling another subchapter 5 bankruptcy case, once a final decree is entered in this case, assuming no default occurs sooner, the debtor could perpetuate this scheme, maintaining her luxurious lifestyles while paying only a fraction of what is owed indefinitely. Such a blatant abuse of the bankruptcy process to shield a debtor found liable for willful and malicious defamation and other torts should not be permitted by the court. So, this is interesting because a lot of people, this is the stuff that you don't see, right? Remember, about a week ago, we talked about Cardi B, and that producer was saying he didn't like hearing how she spends $3 million a month, and he produced on those old ass mixtapes that nobody gives a fuck about. There's about maybe 1,000 people in the world, still caring about that stuff. But he was in a fucked up deal with Cardi's then manager, which Cardi was also in a fucked up deal under the same circumstance. She comes out and says, hey, you don't understand what that $3 million a month is. I got all these legal fees. I got to take care of my family. You know what I'm saying? I got 24-hour security. I got 24-hour drivers. I got, you know what I'm saying? I'm paying salaries out this bitch. But not only that, I think we glossed over the fact that she's having to pay substantial amounts of money to keep tabs on Tasha K's finances to understand why she's not being paid. So that also is a substantial amount of money coming out that's not being reimbursed by anybody. I'm paying more money to make sure that I get paid. Okay. Where was I going here? Luxurious print, blah, blah, blah. Transpired before today or what actions may have taken, but I would caution you about any alterations of your finances or changes to your finances in an attempt to make the judgment less collectible than it is. Under Georgia law, efforts to do that can constitute fraud and can subject you to an additional tort claim and or lawsuit, much less an effort that could be brought in this court to enforce the judgment as it is to set aside actions that you may engage, and given both of you, at least tangentially, are involved in this case by transferring assets. If that were to happen, and I have no information to suggest you would do that, but defendants sometimes do, into the names of third parties, could also subject them to also possible tort actions in the future. So the judge warned them against doing exactly what Cardi B's currently claiming they're doing. Okay. Debtor and her husband knowingly disregarded the court's admonition. So Cardi and team, they're saying the judge came out and clearly outlined what they shouldn't do, and they disregarded it. They spent thousands of dollars hiring multiple asset protection professionals to facilitate the transfer of assets and the establishment of both onshore and offshore trusts designed, to place their assets beyond the reach of Miss Almanzar. If I sound like I'm out of breath, I've been running up and down the stairs, and I had to pause and get back up here. You know what I'm saying? To get back to y'all. As detailed further below, debtor and her husband provided false testimony under oath regarding the existence of the partnerships and onshore-offshore trusts, and deliberately concealed their existence from parties in interest in this court. In addition, debtor knowingly lied when untruthfully answering no in Section 25 of Schedule AB when answering whether she owned any trusts. You lying in your filings? Oh shit. The false statement was not corrected until June 14th of 2024, an entire year after the petition date, when it was addressed in an amended filing made necessary because Cardi independently uncovered the existence of the previously undisclosed partnerships and onshore-offshore trusts. Okay? Debtor and her husband admit moving debtor's assets to avoid defamation, judgment, and garnishment. Over the course of multiple 2024 examinations. It's always interesting to see typos in these high-profile lawsuits. Debtor and her husband testified untruthfully numerous times and plainly contradicted each other's testimony. But debtor and her husband were at least consistent when they both testified that they moved assets in an attempt to avoid collection of the amended defamation, judgment, and garnishment efforts by Ms. Almanzar. With respect to debtor transferring assets out of her name since 2022 to avoid garnishment, she testified. So this is a quote. That's exactly how I meant it. Since you were sued, have you been taking assets out of your name? Ms. Simmons, objection. So I guess that's her legal counsel trying to object the question. The witness, since 2022, yes. By Mr. Moon, okay. Why have you done that? Ms. Simmons, objection. That's funny as fuck, man. It look like a goddamn TV case. Objection. When was the last time you had dinner? Objection. Relevance to the case. Sustained. The witness, to keep my funds from being garnished and not being put out on the street. Hey, she said it in under oath. I've been moving assets to keep my funds, baby. Y'all not finna put me out on the street. Oh, so maybe the 2004 examination, maybe that's a specific title. Maybe that's not a typo. Maybe that's my lack of understanding. With respect to debtor's transfer of the ownership interest in the Georgia property, Mr. Kebe admitted that the transfer was made to avoid garnishment. So he also admits under oath. Why did your wife transfer her interest in the Georgia property to you? He says, I guess to prevent garnishment. I don't know. They continue. Regardless of whether you knew about the transfer at the time, there did come a time when you found out that your wife had transferred her interest in the Georgia property to you, correct? He says yes. Mr. Lieberman, same objection. Give me a second. And you don't And you didn't do anything to reverse that transfer when you found out, did you? No. And you didn't do anything to reverse the transfer because you wanted to help her avoid garnishment, didn't you? Mr. Lieberman comes in. Objection! Calls for a legal conclusion. Mr. Moon, you can answer. The witness says yes. I guess Mr. Moon is the judge. Objection! Oh, shit. With respect to payroll payments for debtor that were being paid into Mr. Keeby's personal bank account to avoid garnishment. Mr. Keeby in a later, it is a 2004 examination. All right, I thought they was talking about the year, but that's the title of this specific examination. On September 15, 2023, tried to change his testimony to say he did not know why his wife transferred her interest in the Georgia property to him. Wow. Telling two different stories in a court of law. Transcript says, but he could not give a reason other than preventing garnishment. And when asked, so do you think it was because of the garnishment, correct? Mr. Keeby says, I think so. Moreover, on the very day debtor transferred her interest in the Georgia property to Mr. Keeby, she contacted Lawyers Limited to create an offshore trust the same day. And debtor and Mr. Keeby were thereafter, in communications with Lawyers Limited regarding their international asset protection plan. The principal reason for creation of the Sambacassi Investment Trust as part of her plan to protect debtor and Mr. Keeby's assets, including their Georgia property. Okay? Now, I ain't gonna lie, man. Hey, you tried it. I ain't mad at you for trying. You know what I'm saying? Like, shit, they finna take everything? Hell no. Let me hire an asset protection company. Let me see what the fuck I can do within my legal right or somewhat legal right. You know what I'm saying? Or to make it look like my legal right to not lose my shit. Hey, man, you got what they say, you only fail when you stop trying. I ain't mad at you. They say, why are you making payments to Latasha into this account that's only in your name? They on your ass to prevent garnishment. Debtor further testified regarding payments for debtor going into Mr. Keeby's personal bank account. Damn. Okay. If I were to tell you that your husband testified that payroll payments from Yellen are being paid to you into the Bank of America account with your name off of it to avoid garnishment, would that be a correct statement? Objection. She says probably yeah. That would be a correct statement because I know the checks that he did write because I didn't look, you know. What? Okay. And if your husband testified that he stopped making payments to you because you told him to stop so it could avoid being garnished, would that be a correct statement? Objection. That would be partly correct. With respect to debtor taking her name off the joint Bank of America account, and you also took your name off of the Bank of America joint account that you had with your husband, didn't you? She said, I did. They say, why did you do that? She said, because it was going to get garnished too after they did the Chase account. Okay? So she's trying to separate these accounts, remove her name, right? So that it would not be garnished because he's not exactly on the hook, right? It's her and her company more so. So he's got his own account. He's got his own company. You know, I don't know what type of activity his company was doing. I don't know if this was a company made, you know, for other services that he provided in the free world, or if this was a company that was created in case something like this ever happened, that they could transfer those revenues over to for protection. I can't say what the intent on that was, but it seems that that's how it ended up being utilized nonetheless. Okay. With respect to debtor's funds, she was trying to keep from being garnished. Debtor testified. So how was he paying for your share of the rent? Objection. The witness. Because he was managing my funds that were coming in that I was trying to hold from being garnished, right? So her money, her YouTube checks, and other websites that produce revenue for her, all were going to his personal account. And those were the funds that were being held at Yellen Entertainment, correct? Correct. Right? So that's where those distributions are coming from, because the money's going to his Yellen account, right? But then the distributions are going to his personal account, and then he's paying her money out of that account so that she can, kind of do as she pleases. Mr. Kibi testified, and at a certain point, she told him to stop paying her, which, of course, you could probably just get an additional card and she could make purchases on his behalf. So, yeah, they was definitely trying to make brownies with a little bit of fudge. Mr. Kibi testified that debtor directed him to stop making payments to her to avoid garnishment. So did she tell you to stop paying her? He says yes. Okay. And that was so you could prevent it from, or she could prevent it from being garnished, correct? He says yes. He admits he was assisting debtor to avoid paying the defamation judgment through garnishment. So you understand your wife was trying to avoid paying my client through garnishment, don't you? Objection. Calls for a legal conclusion. You can answer. He says, I'm sorry. Yes. And you were helping her to do just that, weren't you? Objection. I should have put objection on as the motherfucking thumbnail title. Objection. Calls for a legal conclusion. You were helping her to avoid paying any client, correct? Yes. Mr. Kibi admitted he was holding money for her business, Unwind with Tasha K, to avoid garnishment. Damn. The transcripts is on your ass. When you say you were holding money for Unwind with Tasha K, were you holding that money to avoid the garnishment from Cardi B? Yes. Examination of Chikna Kibi. Yellen was managing the money still, yes. And Yellen was holding the money for you and your wife to avoid garnishment, correct? I think I have already answered that question many times, and the answer is yes, correct? Yes. Yellen was holding Tasha K's money, and Tasha was asking Yellen to manage her money, and they paid towards her bill. And Yellen was holding that money to avoid the garnishment, correct? Yes, and pay her bills. So these are all testimonies under oath where they asked if his business was holding her money to avoid being garnished and to pay her bills, maintain her lifestyle, etc. And under oath in court last year, these were confirmed. And you mentioned before that Tasha K on stage is just your wife's business, correct? Yes. So why is Yellen paying this amount to Flamingo Theater? Oh, wow. Oh, wow. So, remember, this is Tasha K on stage. This is her live show business. Okay. So Flamingo Theater, I'm guessing that she rented out a venue, and the money paid to the venue was paid through her husband's business, not hers. And they're asking why that happened. Okay. So he says Yellen is producing it and managing Tasha K funds to produce it. Okay. They ask, and this event on October 20th is like the comedy show in Atlanta in March, correct? He says yes. Why is it that Yellen would be paying for this event now when Tasha individually was the contract party in March? He says it was launched before Yellen was managing Tasha's funds, so Yellen was paying for it. They ask again, Yellen is managing Tasha's funds to avoid garnishment, correct? He says yes, right? So they tried to find some type of loophole, right, with his business to where she would become, because he's saying that as a company, they're managing her funds. But her funds are still supposed to be subjected to garnishment. You can't just change the company that's managing it and avoid garnishment, but that's what they were doing so that they could maintain their lifestyle, right? At his 2004 examination, Mr. Kebe was asked about the accuracy of a chart prepared by Cardi's forensic accountant, Barry Makamal of Kapila Makamal. The chart was based on financial documents provided by debtor and Mr. Kebe for Kebe Studios and Yellen, and demonstrated that in August of 2022, the same month the Georgia State Court garnishment action against debtor commenced, income previously directed to Kebe Studios from various sources ceased and was instead diverted to Yellen. So all of the money that she had coming in from her different, let's just say, accounts, right? Because you've got Google payments, you've got website payments, and any other ways that she's receiving money. All of that money then got diverted into this Yellen business. The shift was consistent with efforts by debtor and Mr. Kebe to circumvent the garnishment of debtor's income. So these are more transcripts from the courtroom where they confirm that this was all done. Okay? This shit is wild. I mean, it's real life shit though. I mean, I can only imagine how many people have tried to do this. I can only imagine how many people have tried to do this and, got away with it for years because maybe somebody didn't have the money to consistently look into their paper trail. In summary, debtor and Mr. Kebe blatantly disregarded the Georgia court's admonition and orchestrated a deliberate scheme to hinder, delay, and defraud Ms. Almanzar, preventing her from collecting on the amended defamation judgment. Notably, Yellen became a central instrument in their fraudulent activities. The sworn testimony of debtor and her husband clearly reveals how they strategically moved income beyond the reach of debtor's creditors by transferring all business operations from Kebe Studios, a co-defendant and judgment debtor jointly owned by debtor and Mr. Kebe, to Yellen. As detailed above, this maneuver was admittedly aimed at evading Kebe Studios' liability under the amended defamation judgment. Okay? So now they get into debtor and husband, and of course debtor is Tasha K, concealing and testifying untruthfully about the existence of their onshore and offshore trusts. Okay? So I think it's pretty clear here. I mean, we don't got to go through all this to know what's going on. Is that Tasha K and her husband moved her assets, forwarded, I wouldn't even say forwarded, but completely changed, rerouted the destination of her income to her husband's business so that she didn't have to pay money. That's what it is. And then they went off to open up these other trusts, onshore and offshore, where they could also funnel money. Okay? We don't got to waste too much time here. We see what's going on. We see what the play is. And Cardi B is alleging, or her legal team is alleging in so many words, that they're defrauding the people. They're defrauding the courts. They're defrauding the IRS, and they're running a fraudulent scheme to avoid paying Cardi B. That's what it is. Okay? So I'm not finna keep going through this. We pretty much got our solution of what's happened. Now, at the bottom of that documentation, there was grave details of Tasha's finances, and I'm not here to do that. I'm not finna do nobody's forensic profile of how much money they're making on here. That's a violation. So, yeah, that's where we stand. Cardi B is trying to collect her $500,000. She did her a solid by reducing the amount from damn near $4 million, took it down to $500K. They got approximately $10,000 out of Tasha K about a year ago, and from there, it looks like nothing else has been collected because she's been making a lot of different moves to circumvent the system, primarily transferring all monies into her husband's business which then was funneled into her husband's accounts. At a certain point, he was making payments to Tasha, I guess probably into her bank account, or perhaps these were cash transactions. I can't say, but maybe they were being forwarded, sent over to her account, and then some of that money was being garnished, because at a certain point she said stop doing that. So maybe a certain amount of her money then got taken out. I don't know. And she like, hey, we can't do that no more. Stop doing that. We just gonna have to give me that motherfucking card, get an extra one or some shit, or give me your card when needed. Everything we doing in terms of the business, in terms of our lifestyle, it's all on you now, baby. I'm gonna do the work. You gonna receive the payments. I will advise you on how to disperse these funds or how to allocate them, and we gonna run this bitch up until they catch on. Well, as of Friday, December 13th, really this was filed yesterday, Thursday, December 12th, Cardi B and team have caught on. All right. So once again, man, this is just a lesson for all of I don't know if I would call everyone peers, but I guess just folks in this YouTube business, folks in the commentary business, folks that see what's going on in the world, see what's going on in entertainment, music, etc. We come on here, we interpret what's going on. You got to be careful with what you say. Sometimes people don't like the way that I cover certain things. Sometimes they may feel like I'm being a little light-handed on some of my personal judgments toward legal matters or even personal matters that are going on with people. Like, I give my opinion, but I've been doing my best to not judge as harshly on people, because you just never know when they can say that it's a form of harassment, defamation, or malicious intent. So it's a tightrope that you got to be careful about. And if you're not careful about it, and if you find yourself on a campaign where you're just consistently bad-mouthing somebody, and then trying to get into the murky, nasty details of their life and broadcast it to the world, with a targeted hate campaign, and then you find yourself getting sued, you can only really blame yourself. You could be mad at the person for doing it, but you got to ultimately be mad at the person in the mirror. So that's where we stand on that. I'm sure there's a lot of people out there that would love to see Milagro Grams go through this same level of scrutiny, this same level of, legal culpability as it pertains to the Megan Thee Stallion defamation case. That's ongoing. We've been covering it. I've seen some of what Miss Megan Cuniff has said, which, she's a journalist that covers these court cases, civil suits, all these different things. She's got way more knowledge of, the law and how it's enforced in court than I do. And it seems that a lot of her thoughts are reflecting the same as mine in terms of the Milagro situation, where it's like some of these things, although they are clearly malicious intent, although they clearly are coming from a wretched motherfucker, a damn bad motherfucker, in my personal opinion. But in terms of legal opinion and my personal opinion, I don't know where they coincide at all times. Some of it is her personal opinion. Some of it is, I feel like, you know what I'm saying? Versus this is what it is. Somebody saying that you're a liar. I think we all are within our legal right to call somebody a liar, even if they're telling the truth. We do it every day. You know what I'm saying? So I think in Megan's case, they kind of have an uphill battle in terms of proving injury or, pain and suffering and things of that nature. I think that the deep fake thing definitely is going to work in her favor, especially the way that they outlined it in their amended suit. I think that if they can prove that Tory is paying Milagro, money to intentionally come out and harass Megan Thee Stallion, then that creates, that sets a different legal precedent. I think that ultimately fares poorly for Tory Lanez, because then that opens up grounds for them to file another suit against him. Perhaps that creates creates a bit of pushback on his appeals, trying to get out of jail and trying to, perhaps reduce his sentencing or forego sentencing altogether. I think that fares poorly in his favor if they can prove that he's literally paying Milagro to harass her, his victim, really. But we shall see how that unfolds. All right. Now, y'all know I fucks with Megan the long and strong way, but I do believe, as much as I don't see it from Milagro, I wonder how heavily the courts are going to rule over some of the allegations that are made. Some of the complaints I believe are stronger than others. All right. So that's what I'll say in regards to all of this going on. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. Let me know your thoughts down below in the comments. I'm sure some people will disagree with me. But again, it's all about how they determine these things in law, not based on how I feel. Okay? Or how you feel. All right? I'll catch y'all on the next one. Peace.
King of my city in cul-de-sac. Coming out swinging like soldier rags. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive. I need my check. Spinning the block for the Gouda. We hitting the jeweler to flood out the net. We don't do beef on computers, I'm straight out the sewer. We come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. With drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I been dropping these haters like calories. Cross I'm out, I came back with some boundaries. Stand for my honor, but too raw, no corner. Packing the stick with a drummer. When I catch my bad, won't fumble. I done came too far to be humble.